Good morning, everyone, and thank you for joining us for today's Workers' Compensation 101 webinar. I'm Jen Donovan from the board's Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the board's advocate for injured workers. Today, Joe will cover the basics of the workers' compensation system, including employees' rights if they become injured or ill on the job, employees' benefits under workers' compensation, how to file a claim, how to get help with your claim if needed, and best practices for injured workers. We ask you to please keep your phone lines muted as we will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any he doesn't get to, or if you think of something after the session ends, we will be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you would like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are configured so that only panelists can see any questions or comments that come in, so you do not have to worry about others seeing your contact information. With that, I will hand it over to Joe and we will get started.
Thank you, Jen, and good morning, everyone, to the final Workers' Comp 101 of the winter. Yes, my friends, it is less than 3 weeks away from spring, and we have a bunch of these scheduled for the spring. Your trivia for this morning. That's right, Jen did not know we were getting this. Today's March 4. This was, for many inaugurations, Inauguration Day for U.S. presidents. It was switched to January 20 in 1933. That is all of the trivia I have for you today. And thank you, everyone, for giving your questions to us before, as you signed in. When you registered, a lot of people posed some questions, and that was very helpful because I can see what you're interested in. And if we don't answer your question during the course of the webinar, feel free to include it in the chat. I can tell you that we got my favorite question already this morning. Someone who works at a world-class cultural institution, shall we say. The question this person posed was, I'm interested in understanding the whole shebang surrounding workers' comp in our state. I'm just trying to understand it, and this info session sounds well. Now that you have bolstered all of our confidence, let's dive right in. Let's dive into this pool, though, before there's ever an incident, before there's ever an accident. What can we do to create a safer workplace? Well, here is one tried and true idea. Form a labor management safety committee. This is a meeting of workers and management who can discuss the procedures that occur in the workplace, the places where you do your duties, the equipment that you use, the maintenance of that equipment. You can discuss all of these things because these are all of the elements that can make a workplace safer and mitigate any incidents before they should ever happen. So we have on screen, in that green box there, we have an idea of how you might want to form your committee and how you might want to operate it, but you don't have to listen to us. You can find your own way. But the important thing is that everyone speaks to each other, everyone listens to each other and checks things out so that you can correct maybe some situations that are occurring or correct some situations that could create a very bad problem in your workplace. Now to the workers' compensation system itself. The workers' comp system is a no-fault insurance system. That means two things. Number one, we're not interested in questions of who created this, who did this, whose fault is this. It's a no-fault system, similar to auto insurance in New York. So we're not interested in those questions. And also, it is an insurance system, which means there's an insurance payer somewhere in the mix. The New York State Workers' Comp Board is not paying the claims unless there's one instance, and we will cover that in 5 minutes. The employers, though, are providing this insurance coverage. The employers must provide this coverage. If you'd like more detail on how they do that, well, hang in with us because we'll give you some. But the Advocate for Business, my counterpart, also has educational webinars. I think, well, he's on a different schedule than me, but there will be one in March, April, May, etc. And this insurance I'm talking about, well, there's going to be a cost to the employer, but the workers do not directly contribute to the cost of this insurance. There will be no deduction on a pay stub, for example. For comp, but I just want to draw the distinction, paid family leave or short-term disability, the workers could be asked to make a contribution to that. All right, workers' comp is a worker's right. That means it cannot be signed away or negotiated away. And as a matter of fact, you can think of what I'm telling you today as the minimum benefit, the floor. Workers can and do negotiate richer benefits. Immigration status of the worker is not a factor. That means there are no questions regarding where was the worker born, when did the worker come to the US. I'm sorry, we just do not have those questions in this system. Finally, language assistance services are available to workers for free, no charge. We are showing you the page of our agency website that discusses the language assistance services that we have. We're showing you all the different languages. I think there are about a dozen that are where our materials are already translated. And if you need an interpreter to speak with us on a phone call or at a hearing, we will get you an interpreter in whatever language you wish. The Workers' Compensation Board, that is mine and Jen's employer. It is a New York State government agency, and we administer an workers' comp system. There are a little more than 1,000 of us all across the state, and we are able to regulate the system because we receive reports of everything, or we should be receiving reports of everything. The injuries, that means the medicals, the reports of treatment, the notices that the insurers are filing with the board regarding the steps that have been taken, the actions, background documents, payment information, all of these things are going to be received by the board, and they're going to sit in a claim folder. Every claim has a claim folder. And the other thing we do is we hold hearings when appropriate to move a claim forward or to adjudicate that claim. We'll talk more about that. And at the end, we have a little something to say about that at the end. Now, this slide here, the Advocate for Injured Workers, who is this individual? Well, technically it's me. I am known as the Advocate for Injured Workers, and I'm the manager of an office of dedicated people. They do good work, they really do. We are an ombudsman office. An ombudsman is a title that you get in certain fields. Hospitals have ombudsman, financial services corporations and insurance have ombudsman. That's a position where the individual is supposed to care about the health of the system and whether the system is functioning properly. And anyone who knows me knows I do. And my Office of People and myself, we help workers with the more difficult and complex claims as well. We are also involved in fatality claims. We will discuss that in 30 minutes. And we also work directly with the 9/11 community. And we're going to pause here for September 11 because this is ongoing, my friends. If you're not in the New York City area, you might not realize this, but this is still and will continue to be a real thing. And Governor Hochul has put some resources and some education. She's very interested in us making sure everyone is aware of these two items here. On the left, the World Trade Center Health Program. This is funded by the federal government to help people who are impacted by those events receive medical monitoring for their health and then treatment for World Trade Center conditions and illnesses. And on the right side there, the September 11 Victim Compensation Fund. This is also a federal thing. This is operated by the Federal Department of Justice, and there is money available for financial compensation for people who were impacted by the events of that time. And so, if you come to our webpage, we have a couple of learn more. You can click and learn more about these things. These are very good things. We encourage anyone impacted by the events of September 11 and afterwards to please check these things out. All right, that's, and finally, yes, I report directly to the commissioner, the chair of the agency. That's what an ombuds does. You have to go to the person at the top to report anything you're seeing. All right, new topic now. Who pays your workers' compensation claim? This is foundational. You need to understand this if you want to understand workers' compensation. So here we go. Remember I said it's an insurance-based system? So the responsibility is with the employer. If the employer, so what I mean to say is, sorry, the employer has a choice. How is the employer going to provide the insurance? Well, there are two ways. The employer can either be self-insured or buy a policy. There are around 290 different insurance carriers who write workers' comp insurance in this state. So the employer can just buy policy. Boom, done. The other way is that the employer can pursue self-insurance. Now that's going to mean the employer has the finance to set aside money to pay the workers' comp claims out of their own resources. That can become a lot of money. So who can do that? Well, we have public employers and private employers. Public employers are governments. Those are towns and cities and school districts. They can do that at will. They don't need to ask our permission to do that. Private employers? Well, private employers do need to ask our consent to do this, and they're going to have to post a bond or a letter of credit or some form of collateral is what I really mean. They're going to have to post that with us if they're a private employer. So that means they're not going to be Jen's Pizza of Batavia, New York. They're probably going to be a multinational, multi-billion-dollar corporation. Because remember, they're going to need the financial resources to pay these claims. So that's how that works. The important point for workers to take from this is if the employer is self-insured, they are almost certainly going to hire a claim administrator to handle the claims and all the comp matters. I said almost certainly. That means it's not for sure. They don't have to, but they almost always choose to. If the employer bought a policy, that means the insurance company who sold the policy or a claim administrator the insurance company hires is going to be the one making the decisions on the claim. So workers, you will not be dealing with your HR office. You will not be dealing with your supervisor regarding the benefits and the actions taken in your workers' comp claim. You'll be dealing with an insurance payer. Finally, there is one instance when the board, the New York State Workers' Comp Board, will pay the benefits, and that is if the employer should have had insurance and did not. Then the claim comes to the Uninsured Employers Fund, a very illustrative name, wouldn't you say? And the board will advance the payments. The board will also bill the employer personally for these payments. Who needs this coverage? Okay, the advocate for business spends more time on this, but I feel like I ought to explain the concept to you as well. So here you go. A business, when I say a business, I mean for-profit. A business with employees is required to have insurance coverage. What about nonprofits? Most nonprofits with employees are also required to have coverage. Okay? In both instances, you'll notice employees. So, how do we define an employee? Well, anyone who is providing services to a for-profit business can be determined to be an employee of that business by the board, by our employer. Okay, the board is going to be making that determination, not the accountant of that firm, not HR of that firm. The board is going to determine it. And in the nonprofit world, any compensated individual who's providing services to a nonprofit might also be determined to be an employee by this board. There are some pretty limited exceptions in the nonprofit world. We're showing you the two most obvious ones are clergy or teachers in a 501c3. They could be exempt from workers' comp requirements, but they could be covered too if the employer wishes to. Okay, so the whole point here is to let you know that when we talk about employees, it's the board who determines whether someone is an employee or not, and the board is going to use criteria that essentially come down to what we call direction and control. Is the potential employer exercising direction and control over the activities of this worker? You also should understand that there are at least 5 government entities I can think of who are interested in whether someone is an employee, and we all use our own criteria. That's why it's possible for someone to be an employee for workers' comp purposes, but maybe not for tax purposes. Just because someone's getting a 1099 does not automatically make the person not an employee. Finally, last concept on this one, this does include internet businesses like rideshare or task businesses. Yes, just want you to know, like those big rideshare companies, they're carrying workers' comp insurance. Okay, so if you're a worker, you get hurt, you can just file a claim, let us sort it out. All right, so there's been an incident. What do? I just mentioned filing a claim. Let's talk about that moment. When there is an incident, we have a lot of employers and HR people on this session, and that was their number one question. What do we do when there's an incident? Okay, folks, here you go. Number one, workers should get the necessary medical treatment promptly. Okay, take care of yourself. Get your medical care. If you're an employer and you call an ambulance, thank you. You just got notice too, by the way. If you want to drive the worker to the urgent care because it's one of those situations, thank you, but, just remember, go to the nearest place, number one, the nearest qualified place, and number two, if you drove the worker there, or you're a coworker or something, great, but if the worker doesn't want you in the exam room, you shouldn't be in that exam room. It's not a comp thing, it's now public health law. Okay, so the worker got the necessary medical care. Workers, you have to tell the people treating you that this happened at work. Please don't ever, 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 ever say to a worker, don't tell them it happened at work. That's a violation. Okay? Tell them it happened at work, because now they're going to engage in the chain of events that start the claim. The medical people will be looking for the insurance company, the comp carrier, to bill, and you, the worker, you now need to tell your employer in writing that you had an incident. This is so very important because this will move your claim forward. Because maybe your employer doesn't know you had an incident. Okay, maybe you woke up with a terrific backache to the point where you can't get out of bed because something that you did at work 2 days ago. You have to tell your employer so that your employer can now tell its insurance payer. See, that's the key thing here. So workers, tell them in writing. Writing, I recommend an email. You can use a document. Please don't text. You can text if you like, but I dare you to find a text you sent 11 months ago. You're not going to be able to, and you might have to do that 11 months from now. And then when you're done, file your own claim form. Jen is showing you our webpage where we have the electronic version of the claim form. Boy, this is a piece of cake. And you see all those tabs? You're going to go through those tabs and complete them. They're not really the most difficult questions you'll ever answer. Date of injury, return to work. Did you stop working because of your injury, illness? Well, if you click yes, that tells us maybe there's a lost wage benefit that's due. Okay? And if, by the way, there's something about this that indicates you can't do it online, get the paper version and send in the paper version. You're always welcome to do that as a worker. So you're going to file your C3. This is known as the C3. You're going to continue getting your necessary medical treatment. And we want to wrap this little thing up with this. You have 2 years after your incident to file the Form C3. Okay, you have 2 years to file a claim. Don't wait 2 years if you can help it. I mean, you should tell your employer within 30 days of when you know about something that happened. But let's say you told your employer, okay, you have 2 years to file that C3. Like, for example, if you told your employer and the employer and the insurance company never filed this, well, you have 2 years to file it. Okay, now I'm going to turn it over to Jen.
Thank you, Joe. I'm going to step you through a scenario here, and you are going to vote on what you think the correct answer is. So this is about our friend Kadir. Kadir is not an American citizen and is in the US on a work visa. Kadir works 40 hours a week on site at a software company. The company assigns him a desk, equipment, and tasks. He's paid on a 1099. The firm calls him an independent contractor. One day, Kadir is inattentive and drops a computer server, fracturing his left leg. The employer calls an ambulance that takes Kadir to a hospital. So yes or no, should Kadir file a claim? Go ahead and plug your answer into that poll. I'll give everyone a couple moments here. I'm seeing a majority of yeses, a couple no's.
Oh, and we have passed the halfway mark as well. Okay, so points for participation, everyone. Yay! We like to leave it open until at least half of our class, our attendees, give us an answer. Well, Jen, do you think Kadir should
No, I think that he should.
And I would agree with that. We think Kadir should file a claim because we gave you a whole bunch of reasons that indicate, or a whole bunch of facts that indicate there was an incident on site here. It's potentially payable in the comp system. And we tilted it towards the idea that Kadir would probably be considered an employee of this firm. You did not fall for the red herrings that we dropped in about citizenship. Doesn't matter. And we gave you a whole bunch of reasons to think you might be an employee. And finally, the employer called the ambulance. So that could be construed, if the question ever arose, that could be construed that the employer actually had notice of this incident, as well as the employer did the right thing. Let's start talking now about what the benefits are. Okay, there are three. There's medical care, lost wages, and there's a fatality benefit. So we always start with the medical benefits. No cost to the worker for necessary treatment for established injuries or illnesses. And by the way, medical care, remember we're on medical care right now, is a lifetime benefit. Yes, once an injury or illness is established, lifetime medical care. Workers do not need to take any special steps to get medical care for old injuries either, as in workers' comp claims do not close unless there's a Section 32 waiver agreement. To our friends in the payer community, I know that you quote unquote close claims on your books that don't have a Section 32, and that has to do with releasing reserves and some other internal things. That's great. Please do not tell a worker or a doctor a claim is closed if there's no Section 32 in that file. Okay, that's just a little request from me to you. And of course, all the medical expenses are covered. We're talking about office visits or surgeries and the hospital care, inpatient, outpatient, physical therapy and equipment. Medical expenses in general should be covered that are, appropriate for this incident. And then there's one other element we like to make you aware of: travel. So we're going to show you now Form C-257. So if you're a worker and you're going to get medical care, health care, you can file this form. See, the top of it has your general information, and then bottom you would put nature of the expense. Okay, I visited Dr. Donovan. When did you go? On that date. And the amount. Well, what's the amount? If you took a bus, if you're mass transit, you put that amount. You took an Uber or a Lyft, you put that amount. Give us the receipt. Or if you drove yourself, okay, there you would, where did you start? Where was the office? Where did you finish? The round trip. You can include the number of miles and the charge. There is an amount of money payable per mile every year. This year, right now, it's about 70 cents a mile. So you could calculate it and put it in there. You can use one of the online mileage things like Google or MapQuest, because that's what the insurance companies use when they double check you. Okay, so you can file for that. And there's no time limit. You can go back to day one. The mileage reimbursement rates will change year by year, remember I said, but you can go back to day one and submit those expenses. Medical care. Here is a best practice for workers to know from medical care. If your claim is temporary, if you are in temporary world, you need to see your doctor every 90 days to get a degree of disability. Understand your degree of disability. Now, very briefly, it's how disabled you are on a percentage basis. From 0, you're healthy, to 100%, you can't work. We spend a lot of time on this concept in the Workers' Comp 202. So if you'd like to take that one, the next one is March 25, the anniversary of the Triangle Shirtwaist Fire, by the way. And so you could visit our website where you signed up for this, you could sign up for that. But understand your degree of disability. Make sure that you ask your healthcare provider to indicate that if you are temporary. And also, here's another best practice. Please arrive at all your appointments with your WCB case number. That's the number we assign. It'll be 8 characters. It very possibly might start with the letter G, as in glorious. And also arrive with the name of the insurance payer and the insurance case number, carrier case number. It's known as. Your doctor's office will love you because now you're giving them a pretty good chance of actually getting paid for treating you. And we believe in that. You might also, as a worker, be asked to attend an independent medical exam. Okay. This is when the insurance payer is asking you to see a doctor, if fired, to give some expert opinion on some element of your claim. How disabled are you? Have you reached maximum medical improvement? Things like that. Okay, what do you need to know as a worker? Or as a worker? Well, I'll tell you. You're not going to be treated by this doctor. And this doctor is not going to give you treatment recommendations because there is no doctor-patient relationship here. That means anything you say can and will be written down and reported. You may bring a witness. Whatever anybody else tells you, no, I'm your authority here. You may bring a witness. It's that simple. You may also record your exam. You do not need to give prior notice. Again, I'm your authority here. Go with what I'm telling you. Why are you doing this? Well, let's say you recorded your exam. You're going to get a copy of the report that this doctor filed. You are free to check your video against the report and make sure that you can see where everything in that report is coming from. If you don't see where this opinion is coming from, well, if you have an attorney, and you probably do at this point, give the video to the attorney because the attorneys are very knowledgeable from having done this so much. And they might be able to say, oh, okay, here's the point in the exam where that measurement is coming from. If neither of you knows where these findings are coming from, you might want to make a filing with the Office of the Advocate for Injured Workers, because my office, or me actually in my office, receives these complaints about IME conduct. And then we can appropriate people inside our agency. So when I'm talking about conduct, here's what I'm talking about. This little matter of you have a video and the report doesn't match up with the video, well, send me the video. And you might want to note that. If you have an attorney, if you want your attorney to write it, that's fine. You're writing a complaint, okay, and you're sending it to me. Or conduct. That means, were you examined in a medical facility? Were you treated in a professional manner? There's a famous incident I usually cite wherein a fellow in a wheelchair was not examined in a medical facility. The wheelchair could not get into the exam room, so he was examined in the waiting room. That's a problem. That's the kind of thing you want to bring forward. That's conduct. If the IME says you're 0% disabled and your doctor says you should never work again, that is not conduct. That's a difference of opinion that has to be litigated. Okay, and finally, you can claim travel reimbursement to and from these exams. All right, let's talk now about the next benefit, the cash benefit, or as it's known in our system, indemnity. Okay, the maximum benefit for indemnity for lost wages is 2/3 of what the worker was earning on average. we compute something called an average weekly wage, AWW. We look back 52 weeks from incident to come up with the worker's average weekly wage. All compensation counts. Overtime, bonuses, anything else, it counts. Also, workers, if you have 2 jobs, that C3 we showed you, we'll ask you, did you have 2 jobs? Because you need to tell us and the insurance about both jobs. Because if you can't work one, you can't work the other. And the pay from both jobs is aggregated. The maximum amount you can receive in this state is on screen, 1171.46. Okay, that amount changes every July 1st. No, we do not have cost of living adjustments, so you will be at the same potential maximum rate for the life of your claim, and that maximum is based on the injury date. So claims with injury dates from July 1, 24 forward, that's your max, 1171.46. Your minimum is $325 a week as of January 1st of this year. Slightly different date, but the minimum dates are fixed to January 1, 25, $325. Last year's minimum was $275. And also 18 months, it's going to be indexed the same way the maximum is to New York State's average weekly wage. But, you know, we're talking about a $325 minimum. If as a worker you actually earned less than that, then you would be receiving your full wages. Now, what are we talking about here? Well, remember I said all claims are temporary at first? Okay, they're considered temporary, and most people, they come back from temporary total, temporary partial, and they come back to work. Most people do heal fully. However, it is possible that you might not fully heal. That would put you in permanent. So you would either be permanent partial or permanent total. And we have a lot to say about this in the Workers' Comp 202. So if you need more information, feel free to join us on that one. So the point here is that permanent benefits are possible. And there's also something that pays workers if they lose part of the use of one of their limbs. Now, by limb, we are talking about a hand or fingers or an arm. We're talking about leg, a foot, or toes. Each finger and toe has its own amount of money that is payable if you should lose part of the use of that limb. We also want to point out that on our website, we do have a number of publications, and if you should ever visit our website, you know, we do have all these publications available that Jen's unit, the communications unit, is keeping available for you. We believe in education. Here's a best practice for payments: direct deposit. If you're receiving payments, if you're an injured worker and you have a bank account, or you can get a bank account, would you please consider using direct deposit? It's 2025, my friends. Why on earth are you waiting around for a paper check? Okay, that's all I have to say on that subject, but I hope my emphasis comes across. And also, if you get paid in cash, why don't you keep some records about your payments, okay? Why don't you get a notebook and write down who paid you, on what day, for doing what amount of money? This is what we call a contemporaneous record. And if you ever need that record, like, oh, I don't know, maybe you got hurt and you're filing a comp claim, and you remember that Joe said you're going to need to tell us all the money you earned for your benefit, that's a really good way to get to the right amount. There's one more benefit that we want to cover. It is the fatality benefit. And this is a benefit where you very possibly might be dealing with my office because we do help families pursue this benefit. We do make an awful lot of people aware of this benefit who never knew about it. Funeral expenses, memorial expenses. If you are in the classic definition of the New York City metro area, New York City, Long Island, Westchester, and Rockland County, up to $12,500 is reimbursable. The rest of New York State counties, up to $10,500 is reimbursable. We'll need to see the bill, okay? Then from there, weekly payments are possible to the surviving family. We look first for a spouse, no spouse, or we also look for children. Children up to 18 are eligible. They're eligible up to age 23 if they're in accredited higher education, or they could be eligible for life if they are a blind or disabled dependent of the person who passed on. Okay, so that's the order that we look for, and we're going to compute the indemnity benefit. We would if the worker was just unable to work, and then those parties would share that benefit. If those parties came off eligibility, the other parties would just get a bigger share. Now, if none of these people exist, $50,000 is payable to the parents of the deceased. And then if there are no parents, $50,000 is payable to the estate. If there is a beloved cousin in Illinois who wishes to, or who believes he or she or they should share in this, they deal with the estate, not us. Now, there are two nonprofits who provide scholarships to the children of workers who either perished or were very seriously injured. Kids Chance. Kids Chance of New York is what we're showing you right now. These folks have a scholarship available for those kids. See on screen, scholarships for children of New York's fatally or seriously injured workers. Okay, it's a national nonprofit. We're not related to them in any way, but we do make you aware that they exist because they definitely do have scholarships available and they are very interested in an application. The other group we'd like to show you is the Triangle Shirtwaist Factory Fire Memorial. This is another group who has scholarships available for the children of workers who perished or were seriously injured. We're showing you their website right now. So you can apply to both, but they also have scholarships available. And it's March, as we decided, it's March the 4th. So that means that students going to college are getting their acceptance letters now. How are you going to pay for college? You typically want to sort that out by May 1st. Why don't you consider checking out one of these scholarship organizations if this is right for you? Jen is going to give us another educational moment.
Thank you, Joe. Okay, our next scenario is dealing with Liz. Liz worked full-time as a bartender at an upscale restaurant. She also worked some mornings at the family hardware store. Liz had a serious incident with a box cutter at the hardware store. She missed 4 solid weeks of work from both jobs, rated 100% disabled by her treating doctor. True or false? Because she was hurt at the part-time job, Liz's benefit will be based on her earnings from that job, and the restaurant pay and tips are not included. Is that true or false? Go ahead and select your answer from the poll. We're going to give everyone a couple more moments here. As Joe mentioned, we like to see at least a 50% response rate.
And pay attention to the wording of the question, my friends. But that's, just make sure you get the concept too. Remember, Liz was hurt at the part-time job, but she has two jobs. So is her benefit going to be based only on the earnings from the job where she was hurt? Or, is it going to be both? Is it going to include her pay and her tips? So if you think that it's only based on the part-time job, answer true. If you think all her jobs are included, answer false. All right, Jen, I think we're going to continue on. The answer that we were looking for here was false, which most people have indicated. Just want to make sure people are not falling victim to the wording of the question. But the concept we're trying to get across here is Liz has two jobs, so both of her jobs will be considered in the calculation of her lost wage benefit. So she does get tips. The tips will also be considered. If her tips came in cash, that's okay, because Liz took a webinar where some guy said, write down what you're earning in cash in case you ever need it and you can report it. Okay, so yeah, you want to capture all your earnings from all your jobs. Thank you everyone for participating. Penalties for late payment. There are some. We're talking about a lost wage payment. You can't work and you lost wage benefits. Well, the payers should begin paying those benefits within 18 days of the incident, assuming the claim is complete, or 10 days from when they got notice, whichever is later, or penalties are possible. Also, let's say you have a hearing, there's going to be a decision. The payments should be made within 10 days of that decision, the filing date of that decision. Filing date will be in the lower right-hand corner of the decision. If you are receiving ongoing benefits, this is why I'm asking you to please do direct deposit, because if you have direct deposit, you will almost certainly get your benefits every 14 days like you should. Because otherwise, if you have a paper check coming your way, well, here's the rule, my friends. That check is not late until it's 25 days late. Yes, 25 days late. You're accustomed to getting it every other Tuesday. And then finally, if there is an appeal, interest might be due after the appeal is decided, and our friends in the payer community will make that calculation. Let's say you're a worker. You do have some responsibilities here. Please try to come back to work as soon as you're physically capable. Let's say you're at the point where you're not 100% healthy. So you might have like a 25% disability. You're healing, but you're not quite there yet. Talk to your employer about what's known as transitional duty or light duty, or what they call return to work. Because enlightened employers will make an effort to accommodate you and bring you back. That's good for everyone. It's good for the worker because it helps with the healing. It helps get the worker ready to return to the job full time. It's good for the employers because you get a contribution. You might get something done that you needed done that you couldn't get done because it's an alternative duty. But it also takes the worker off indemnity, which means there's no pressure on your premium because they're not paying, carriers not paying an indemnity benefit any longer. Also, eCase. If you are a worker, please consider signing up for eCase. We're showing you the eCase page right now. This link is right at the top of the website, our website. If you want to sign up for eCase, it's this simple. a driver's license or not a driver's license. We have both ways. And then you can see what you saw, what you have to do. This is all you have to do. What's your name? What's your address? I mean, what's your contact info? It's really this simple. And then you can see everything in your file that everyone else sees. Okay? There's no more mystery about what's in your file. I strongly recommend, if you have an ongoing claim, sign up. All right, this is our last major topic. You might have a hearing in your workers' comp claim. And if you do, it's going to be scheduled as virtual unless you have a virtual and then you ask for your next one to be in person. Then that could happen. You can come into a board office and have an in-person hearing. You and your attorney would have to do that. So let's say you're having this hearing. Okay, you have an attorney, do you? Well, if you don't, you are free to retain one, no problem, because the insurer is going to have an attorney. And there's going to be a law judge who works for the workers' comp board, who's going to make the findings. There could be witnesses. They could go over depositions. And just want you to know that the board does not use the formal rules of evidence and procedure that you get in courts, civil court, criminal court. We don't use those same formal rules. We are a little less informal to that extent. We're not actually a court either, by the way. There's no gavel, there's no bailiff. But we do have an element of decorum and professionalism like you would get in a court. And so just want you to know, if you are asked to attend the hearing and you're the worker, you should attend the hearing. You really should. If you have an attorney, you should probably follow your attorney's advice as well. You'll have enough lead time to get to the hearing too, by the way. All right, here's our last element here, the Injured Workers Toolkit. We put this together for workers. Look at all these incredible resources. And there's a version in Spanish right here too, by the way, if you want to click that, if you're a Spanish speaker. But look at these incredibly helpful resources we have. On the left, you can see the major topics. And then we have all of these links active that you can click and get more info. This is just a really good thing. Jen's unit came up with this. It's a great thing for workers. You can, Jen, click that healthcare provider IME search. Let's say you need an authorized provider. You click that. You can find yourself an authorized provider right from this page. There it is, that big green box. You would just click that, and then you put in what type of provider you want and your zip code, and boom, there's the list. Okay, so I really recommend you look for the Injured Workers Toolkit. It's just a great one-stop for all of these elements that you might really benefit from in your claim. Here are our social media handles. The fourth one, the YouTube, really recommend that because we have so many, we have hundreds, don't we? Hundreds of videos at this point. Hundreds of videos of the educational nature are there, including this.
Yeah, actually, Joe, if I could just interject for one moment, I am seeing a lot of questions coming in the chat asking if this presentation will be available. It is currently available on the YouTube channel that Joe just mentioned. So be sure to check that out. The other thing you can do is visit our website, wcb.ny.gov, and if you navigate to the Advocate for Injured Workers page, there are additional resources there, as well as recordings of this that you can take a look at.
All right, we're going to leave this slide, review your questions. This is how to get more information out of my office. There's the phone line. There's our email. If you send in If you make a call and you come into my office, you don't have to wait for our staff. We are very fully staffed, and I love that. You send us an email, I might be replying to you. You might get a response within 2 minutes and be delighted that government responded to you that quickly. If you write to the outreach mailbox, you might also get a response that quickly because we care about these things, my friends. So, Jen, what do you say we consider the question?
Yes, so everyone, you might hear a brief silence while Joe and I take a look at all the questions that came through the chat, but we will be back with you momentarily. Thank you. Okay, everyone, thank you so much for your patience. We are going to dive right into these questions here. We have a question from someone waiting for approval for a procedure since February 17th of this year and looking for a reason for the approval time.
It sounds like our questioner, our injured worker probably, has a provider who has filed some sort of a prior authorization request for some form of treatment. Very good. And the request was filed on February 17, 24. So that is a little more than 2 weeks ago. Okay. Well, we do cover this in great detail in the 202 webinar, but each step in this prior authorization process has a number of days. Well, it goes level 1, level 2, and then level 3 if needed. So level 1 is the insurance company has probably a nurse who's looking at it. And that should be accomplished in 15 days at the outside, I think, unless there's an IME, which then gives it 30. Point here is, why don't you give my office a call? 877-632-4996, or send us an email. Give us a call and let us check the file for you, and then we can advise you on what's happening. And something might have happened that you don't know about. Okay, you might have gotten an approval or a decision and you don't know it. Let us help you with this one, please.
Thank you, Joe. Okay, our next question here, we have someone who is working at a state facility and was injured. The injury required surgery on both knees, and now this person is 100% disabled. We are so sorry to hear this. This person is looking for information on how to get disability assistance.
Right, that's the phrase used, disability assistance. Okay, well, the scenario that we're seeing here indicates this happened at work. So disability assistance would be known as workers' compensation benefits. So I'm hoping that the worker advised the employer of the incident and that this is being processed as a workers' comp claim. The worker does mention using sick days. Okay, that says to me either it's not being paid by the workers' comp carrier, or it is, and the worker is supplementing with sick days, which is allowed because remember, the benefit is 2/3. So what do we do for that other third? Well, you can, if your employer permits it, you can use sick time to supplement that other third to get you back to full pay. I'm also going to recommend this worker give my office a call or send us an email. You can do this via email. Just always give us the WCB case number if there is one. This person, we're going to need your name and your employer and your injury date approximate to see if there's even a claim. If there's no claim on file here, based on what you're telling us, it certainly looks like there should be. We'll walk you through this.
Thank you, Joe. We have a question here about webinars for TPAs regarding responses in the New York portal. The board is in the process of putting together some new webinars for payers and providers, so keep an eye out for that. If you are not currently signed up to receive notifications from us, that would be a helpful thing to do. You will be made aware of when these sessions are going to take place. To do that, you're going to visit our website, wcb.ny.gov. You're going to scroll all the way down to the bottom of that homepage and click on the button that says Get WCB Notifications. You can pick and choose what alerts you sign up for, so we're not going to bombard you, but this way you will be aware when new webinars become available.
Thank you, Jen.
Okay, our next question. If I've had 12 visits to a physical therapist for a body part and more visits got denied, how do you or can you get on maintenance?
We are again in the prior authorization process. So our worker here has received 12 visits for physical therapy. Great. More visits were requested and it was denied. Okay, this is one where you would also want to make a contact to us because what I'm doing, my friends, is solving these out loud with you. What we would do when we got the contact is we would look in your file and we would look for that denial, and then we would see what it said, because we're going to look at who denied it. Was it denied at level 1? Okay, that happens. There is, I'll tell you what we would be telling you. There's the possibility that the level 1, well, it's not even a possibility. The level 1 must go to a doctor at the insurance company for level 2. And then the doctor at level 2 would make a determination. So either that didn't happen or the doctor also denied it. So what that means is the prescribing provider, the treating, now has a decision to make. Does the prescribing provider wish to push it up to level 3 where the board has to review it based on an opinion of, yeah, I disagree with what they're saying. I submitted everything and what I'm saying clearly shows PT is warranted. Or the prescriber could say, oh, based on what they're telling me, maybe I should tell them this, this, and this. So that would mean the prescriber would just refile it and go back to level 1. So, short answer, we need to look at this. Contact us. Jen, we did get a question that I would like to summarize. It's a very lengthy question, and it is from the person that we were writing to before the webinar started, because this question started coming in before the webinar. You all probably didn't see it, but we saw it and we were corresponding. It is to our friend who had a discrimination claim and our friend did not prevail and the case was disallowed. Okay, here's what happens. If your case is disallowed, you may appeal it. And as you know, you're going to file Form RB89. We at the board, we cannot tell you what to put on that form, and there's really not much help we can give you to complete that form, because the only help we could give you would be to say, fill in all the fields. You can type it online and print it and mail it in, or you can type it in and save it PDF document and then submit it electronically. But I'm sorry, that is really all the information we can give you about how to complete that form, because if we give you more, we're giving you legal advice, and we are the government. We cannot give you legal advice. So I'm sorry about that. What else do we have? Jen, there's one here that let me give the question and the answer at the same time, okay? There's a question about A worker wants information from the previous employer. Okay, just ask. If they're not giving it to you, they're not giving it to you. Okay, we can't compel them to give you certain information, but the worker wishes to find an appellate appeal lawyer. And do they charge upfront fees? No, they do not. If you want to file an appellate appeal, though, you are going to have to pay a fee to the appellate division, unless they have some sort of a waiver program. I don't know about that. So the best answer we can give you here is you want to contact the Bar Association. They'll give you the names of attorneys who might represent you. You might want to contact the the Injured Workers Bar Association. They might give you some names as well. We can't give you particular names, but we can give you those resources. All right. Why don't we do that question about the is compensation taxable and getting the holiday tip back?
Yeah, so we have a question here asking if compensation is taxable and would you get your holiday and sick time back?
Workers' comp is not taxable, it's tax-free, okay? That's why even though we're in tax season, you're not getting tax forms for your comp. We do get this question once in a while. There's no tax form to give you because it's tax-free. How do you get your sick time back and your holiday pay back? Well, did you have an established claim? If yes, then your employer should be restoring. Okay, you might not get all of it back. Remember, let's say your employer used sick and vacation pay to give you 100% of your pay. Remember that comp is 2/3. Well, there's the question of that 1/3. So you should be getting back the 2/3 for sure. The 1/3 you might not get back because it's outside of the comp area. Remember, it's comp's 2/3. So show your employer the decision or whatever we sent you that says your claim was established. If you need us to create something explaining what your benefit was, we can do that for you. Our social work unit actually handles that. So you can write to social workers at wcb.ny.gov and ask for that, or you can write to my office at the address on screen. We will get it to social work for you. We are good at helping people.
So we have another question here that I believe is related to informing your employer about an injury or an illness. Does it matter if I sent a text message in our work group chat where my supervisor was present and responded?
Yes, it does matter. That means that you're giving your employer notice of your incident. Yes, you are permitted to use a group chat. It's a little indelicate and it's, you're telling the whole world your business. But yes, your supervisor has responded. Okay, so that means that they did have notice. You might want to capture that somehow, screen capture or some way. You can follow it up with an email and you can reference this. That's, I recommend you do that. But yeah, it sounds like you have already given notice.
Okay, our next question here. If there is missing or incorrect information on the original C3 filed by the employer on the employee's behalf and the insurance company denies payment of the medical claim in the workers' comp network based on this information, how does the injured worker amend the original C3?
Okay. First thing is I'm just going to gently correct the terminology. Employers don't file C3s. C3s are filed only by workers. Employers file something else. If you really want to know what it's called either a first report of incident or a FROI, or a subsequent report of incident or a SHROI. That's number one. Number two, I'm explaining this to you now in a neutral manner, so please don't be offended or hurt, but here's the way the system would view this instance, and we have to know how the system would do it. This is you saying that there's incorrect info. The employer and the insurance payer might say, no, this is perfectly correct, the worker's wrong. What that means is we have a moment of contention here. You say one thing, they said something else. It's going to have to be litigated now. It seems that the payer is denying something. They're denying payment to a medical provider. Okay, well, if you point out that they're wrong about something, if they wish to maintain their denial, they have that prerogative. And so it's going to come to the board to now be resolved. Okay, that's what happens. There's nothing that's going to be amended unless they suddenly wish to pay. If they don't suddenly wish to pay, it comes to the board and we have to resolve it. Here's an interesting idea. Someone is wondering if the workers' comp board, our employer, makes a direct contact, I think, to each individual worker when they get hurt. You should be getting mail, but other than that, we don't have the resources to make a phone call or a visit. We don't have the resources to do that. Well, you should be getting some mail about your claim. If you're not, contact us. Let us take a look at that. Yeah.
All right, so we have a question here. Do attorneys have a deferred or contingent payment system based on only if you win your hearing?
Well, first of all, I'd like to say hi. I know this person, and it's great seeing you again, even if it's through here. And second, attorneys and payments for their services when they're representing workers. Pretty sure we're talking about workers here. The attorney is only compensated if money moves to the injured worker. If the injured worker receives no indemnity award, either because the claim's disallowed or it was a medical only claim, then the attorney is not being financially compensated. If, though, there is money moving to the worker, then the attorney has to file a bill, and the board, our employer, has to indicate that, yes, we are approving the payment in this amount. And the law was changed a few years ago so that there is far less variance. The judges have far less discretion today than they used to have. The law is pretty clear on this amount of money based on a percentage to the lawyer for this service. They use a percentage. The maximum percentage is 15%. Okay, there are other systems that have different percentages. In this one, the maximum percentage is 15%, and it could be less.
Okay, our next question here. How does a medical provider get information on the employer's insurance policy to ensure payments if the injured worker does, I'm assuming this is does.
Great question. Great question. Okay, here's what you do, medical provider. You ask your patient where the patient works. Okay, so now that's going to tell you a lot. You may end up contacting the employer and asking them, who's your comp carrier? Because I treated one of your injured workers. That's probably how you're going to get it. You might, if you're treating a lot of patients, you might start to learn who the payers are. You might learn that, for example, if you treat someone who's employed by the great state of New York, that's going to be New York State Insurance Fund. The state of New York is insured by the New York State Insurance Fund. You can count on that one. You might have a major employer, in your town. So yeah, ask your worker. Your worker might know. If your worker doesn't know, you might end up contacting the employer to get that info. Oh, you know what else you can do? You can come to our website and you can put in the name of the employer and we will show you who the insurer is. That is right on the front screen, wcb.ny.gov. Okay, you can help me out. What's the question on that one?
So I believe it's a follow-up to this one.
Oh, what do we do if there's a section 32? Okay, thank you. Jen's helping me sort through the questions here, quite expertly, actually. She does a lot of these webinars. Okay, so what if there's a section 32 this medical office is asking? Okay, here's the scoop on that. A section 32 is a section 32 waiver agreement. It is a settlement. It is the only thing in this system that you can call a settlement. People use that term casually. I'm giving you the proper usage now. In a section 32, the worker and the payer are closing either the medical care or the indemnity or both. They choose. There are some section 32s that leave the medical care open. Okay, so it's a regular comp claim. If, though, the section 32 closes the medical care, that means that the worker took a payment of funds and put it in a special account to pay for medical care. That's where your payments are coming from, providers. So you will bill the worker the comp fee schedule amount, and the worker or whoever's administering that account will write you a check. If that money is depleted and all gone, you're going to have to look for some other insurance. But the point would be, if the medical got closed on a section 32, that worker left the workers' comp system. And if that money's been depleted, you're going to have to look for some other insurance or the worker personally to pay. You are out of our jurisdiction. Tony, this is for our friend Tony, who uses the Injured Workers Toolkit. Whomever would like to use it. Okay. What should I do? Yeah, let's.
All right, our next question. What should I do if there is a misclassification? Where can I get training to learn more about workers' compensation?
All right, to the person who posed this question, what should I do if there's a misclassification? Are you talking about a misclassification of employees for premium calculation purposes? If so, you want to talk to the insurance company and make sure they have the right information. If you and the insurance company still disagree, you can go to SIRB, NYCIRB, the New York Compensation Insurance Rating Bureau. If you're telling me that you know about someone who is misclassifying workers to get over on premium deliberately, that's a crime. You can certainly report that to our compliance bureau. If I gave you all these scenarios and none of them pertain to what you mean by misclassification, please feel free to clarify your question in the chat. And then where can you get training to learn about workers' comp? Well, you're taking some right now. You can take the 202. You can take the Advocate for Business seminars that we offer. You can talk to your employer about training. I don't know what your role is, so I don't know what training you're actually looking for. So that's what we have on that one.
And our next question here, what about reduced earnings benefits for gig to gig workers? I'm an actor, singer with an ankle injury, and the show I got injured in ended. We're sorry to hear about that. I did not have a job to return to, and I had to turn down many auditions for jobs I wasn't fit to do.
All right, I'm glad you posed this question. Jen, did you know we get an awful lot of attendees from Actors Equity in our webinars? And thank you all. We totally support you. Not only your work efforts, but who doesn't love a Broadway show? Okay, here's the thing. Let's look at the big picture. We have an actor-singer who got hurt in a show. That show was carrying comp insurance. So if it wasn't, you need to tell us. That's a problem. But let's hope that they were like they should have been. Okay, that insurance company owns this claim for the rest of your life. So it doesn't matter if the show's open or closed, you're still dealing with the same insurance company. So they should be paying the benefits. If you're still disabled, you should still be getting benefits. If you heal and you return to work, but you earn less, you might be eligible for reduced earnings benefits, like you're saying. Reduced earnings benefit is payable in that scenario. You used to earn $2,000 a week, but now you've healed and you can only earn $1,000 a week. Well, you might be eligible for 2/3 of that $1,000 a week difference, or $666 a week. You might want to contact us to have us review your claim to make sure everything's working out as well as it ought to. But that's the basic principle here. That insurance company has your claim. You should be receiving the benefits that you ought to be receiving, even if your show closed. All right, let's see what else do we have? Well, okay, someone posed a question rather indelicately, so I'm going to just answer it. Your insurance payer does have the right in the system to take advantage of all of its rights and its prerogatives. So it does have the prerogative to review requests and say yes or no. Now, if it's saying no inappropriately, it could face itself a penalty. But if it does have the right to say no to your claim under the law, and it does, I'm genuinely sorry about that, but that might not be something that is inappropriate with respect to the system.
Before we get to our next question, I did see one here again asking if this will be emailed. And the answer is yes. You will see an email in the coming days. Be sure that you are signed up to receive those notifications. So again, wcb.ny.gov, scroll all the way down to that home page, click the box that says Get WCB Updates, and make sure you're signed up so that you receive those when they become available. Okay, I think, Joe, that this is a follow-up to previous email, our actor singer. Doctor and physical therapy office both think the other entity needs to authorize another round of physical therapy, and neither seems to be able to do so. So I'm months away from physical therapy that was prescribed but not approved.
All right. We did sort of cover this in a different context, but I'll just give it to you again in your context. The question did come in a while ago too, but just so everyone knows, the doctor prescribes physical therapy. So the PT office that's going to render the treatment, they are not involved in the authorization process. The prescriber has to do the process. The prescriber is welcome to review denials and resubmit as necessary or escalate to have the medical director's office review a denial. This individual, I think we've already said, why don't you give us a contact? Why don't you give us a contact? So we can look at this, but that's how it goes. And no, you're not months away from PT, because the review process, these things can get turned around in 4 days and then another 4 days. So no, you might not be months away, but let us take a look at this. Oh, let me do this one, John.
Okay.
This person is remarking about what happens. I think we did address this. What happens? Yeah, what happens when an adjuster says there is a Section 32 agreement in place and the case is closed? Okay, in that instance, the adjuster is correct in telling you the truth. There is a Section 32 agreement in place. The case is closed. The worker has left the workers' comp system. So you're the medical provider. You're treating that patient. Thank you. How do you get paid? Well, your options at that point are, number one, is there a medical account that is funded to pay for your services? If yes, you're going to bill the workers' comp fee schedule. That's what we were saying earlier. If no, there's no money left in that account, then you and your worker have to examine the options of other insurance systems or self-pay, because once the worker takes a 32, the worker has left the comp system.
Okay, our next question here. Is there a limit to how many physical therapy visits you can have annually, even if your injury affects multiple body parts?
There is not a limit because we have the variance process. So for maintenance care, 10 visits, but we have a variance process. So a patient might need more than that. That's why you file the authorization.
Okay, our next question here. I will be working with workers' compensation. Where can I find the correct worker classifications? Where can I find training on this topic?
All right, this is an individual who is on the business side equation. Worker classifications. Okay, this is actually a premium question, and this person wants to know, how do I tell the insurance company who's quoting me what my employees do? Because there are 4-digit classification codes for all of the tasks that people might do. Like if you're a roofer, there's a 4-digit class code that says you work on roofs, and it has a cost associated. So to the person doing this, you want to be in touch with the New York Compensation Insurance Rating Board, NYCIRB. I think they're a .org. We might be able to check that out for you. But they have all of these worker classification codes, and I've seen it. It's a massive book. I think you could just download it. I think you could just get it online, piece of cake. And it is nycirb.org.
Okay, here's another question. Is it legal for IME exam offices to post no cell phones allowed?
Well, I don't answer yes or no on legal, but I can tell you the system, which is, if there's a sign that says, please don't be talking on your cell phone, okay. I think we could all conform to that. If there's a sign that says you cannot have a cell phone in this office, you don't have to follow that, because if you want to videotape it with your cell phone, Joe is telling you go right on ahead. So remember, if you want to videotape it with your cell phone, go right on ahead. If you want to take photographs, go right on ahead.
Really quickly, did you mention this already, Joe, or can I mention this?
Go on ahead.
So, a follow-up to the person who is the actor and singer, we got a comment saying, please tell this individual to reach out to Actors Equity. They offer assistance. So that is for you. I hope that that helps.
You know, I think you helped me with it, a webinar for Actors Equity. And if you all want another one, just get in touch with me. And that's a good way to say to everyone. Let's say you're in a group. If you would like a webinar for your group, feel free to get in touch. Use the email on screen, and we can arrange a session strictly for you. No problem.
Okay, for physical therapy visits that got denied, it got to a level 3, but the case is older than 25 years. Are the rules different for older cases? And at that point, does it go to maintenance?
The rules are not different for older cases. And if by rules you mean level 1, level 2, level 3, no, they're not different. Are there different considerations for each claim and each person? Well, yeah, there could be specific elements to each, but rule-wise, the 25-year-old thing, that in and of itself is not something that's going to be different than, a case that happened, an injury that happened 2 weeks ago. Yes, diagnostic workups, if they're part of treatment, yes, they could be coverable in the workers' comp system. If you have additional testing that you need to determine the specifics of an injury, you're going to look at your treatment guidelines. I'm talking to doctors now. You're going to look at your treatment guidelines and you're going to see if what you want to do is automatically already approved. If it is, well, we've already thought of that, go on ahead. If it's not automatically approved, but you need it for some purpose, file the treatment request, the prior authorization request. So, yes, go ahead and practice medicine as you would. Check our guidelines to see if it's already approved or if maybe you want to get a prior authorization requested.
Questions we have.
I'm going to go ahead and agree with you, Joe.
Okay, if you do think of anything else, the phone number and email address is up there on your screen, so you can get in touch with Joe's office directly. Just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars straight to your inbox. Again, to sign up, visit wcb.ny.gov, scroll all the way down to the bottom of that homepage and select Get WCB Notifications. We also distribute information via our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. We thank you all for joining us and enjoy the rest of your day.